Hey, this is Lee and Brad, and today we are getting together to discuss guarantees, one of our favorite topics, more specifically, guarantees in the context of holdover rent obligations that might exist in a lease. Brad's going to talk about an appellate division decision that came down today, so it's very timely. And then we're going to talk a little bit about the impact that decision might have on leases moving forward, guarantees, and pending and future litigation involving the topic.
So, what is a holdover tenancy? In brief, a holdover situation or holdover tenancy is created when a tenant remains in possession of a premises after the end of a lease term, whether it's an expiration, usually, or the lease is terminated in some other way. And today, as Lee mentioned, the appellate division first department in a case called Archives L.L.C. against Joseph Volpe and Jeffrey Cohen issued what we think is a fairly significant decision regarding guarantees and the way lease guarantees function in a holdover scenario. And what the court held in this case is what we believe for the first time is that a lease guarantor is not liable for holdover rent unless the guarantee explicitly says that the guarantor is going to be liable for holdover rent. What we often see is a guarantee that says the guarantor hereby guarantees performance of the tenant's obligations under this lease. What the appellate courts have now said is guaranteeing obligations under a lease or under this lease does not mean that the guarantor will be responsible for obligations that arise post expiration of the lease, which obviously includes holdover rent. And, the immediately significant takeaway from this is that it's really important for guarantors because guarantees typically, leases typically specify that holdover rent is going to be some multiple of base monthly rent. What we typically see is 2 to 3 times the base monthly rent.
Yeah, I think in practice, there are a number of ramifications. I think it's helpful for a second to just explain in clear terms the typical fact pattern we see this in. You have a tenant, typically in New York City, small tenant, doesn't have a lot of assets. The business is going bad. They need to vacate, or their lease is terminated because they don't pay. Most commercial leases have a guarantee or a good guy guarantee where the principal is on the hook for all outstanding lease obligations, either through the date of vacate or past the date of vacate, depending on whether it's a good guy guarantee or not. So what you often see is a lawsuit brought against a tenant that has no assets to satisfy any obligations and an individual who does have assets. And that action is brought by suing under the guarantee. So this decision is very important because if a tenant holds over, the guarantor might be liable for, and will be liable in all likelihood for the rent and additional rent due through the date of vacate, won't be liable for any holdovers or any post expiration rent. And, I think this is going to require landlord attorneys to pay a lot of attention to the wording and guarantees. What we kind of know happens both from a transactional litigation perspective is the guarantee is the last thing that you look at. The lease is an 80-page document. The guarantee is usually a page or two. It's boilerplate, and both sides might edit it a little bit, but not a lot of attention is paid to it. Now landlords are going to have to very carefully review their form guarantees and ensure that holdover rent or post rent use and occupancy is explicitly covered, because again, this case could foreclose a landlord from going after holdover rent against the guarantor unless it's specifically included in the guarantee. And I think what's really interesting is, there's always an abundant caseload when it comes to breach of guarantees in New York County and every county in New York State. It's going to have an impact on those cases. those cases where landlords are seeking holdover rent against the guarantors, this decision is going to be oft cited to over the course of the next couple of years.
Yeah, and I'll just piggyback on that and say, obviously, this is, I think, transactional attorneys, whether you're representing landlords or tenants, should take note of this decision first and foremost. But by the same token, when these cases come to litigation and parties are litigating a guarantee, not to lose the forest for the trees here, it's really important to scrutinize the actual wording of the guarantee at issue. Many of them are boilerplate, as you said, but they're not all the same. Guarantees use different language, and a body of case law that previously existed and is growing stronger says that guarantees are to be interpreted in the strictest manner possible. You really need to scrutinize every word of the guarantee. And I think a kind of broader takeaway here is don't just go with the conventional wisdom that, okay, there's a guarantee, the guarantor is really going to is really going to follow everything that the tenant is liable for. We're seeing courts really pick apart the obligations of the tenant versus the obligations of the guarantor. As I said, if you're litigating a case where there's base rent owed and there's a standard guarantee, there's probably not going to be a whole lot of disagreement or room for argument about the guarantor's obligations. But now when we get into a post-expiration world and you're looking at this obvious example that we're talking about, holdover tenancies, you've really got to look with a magnifying glass at whether the guarantee, it's really a question of scope. Does this guarantee cover the obligation at issue? That's really important to keep in mind.
Yep. So we'll continue to keep an eye on this body of case law. I'm sure we will see a number of decisions follow from this, and we'll keep everybody abreast of what's going on in the exciting and ever-changing world of guarantees. Thanks, Brad.
All right, we'll leave it there.